Welcome to this talk about sociology of law. We are standing here outside the medieval castle of Landskrona. It is a castle built during the 16th century, and it has played a role in history as a focus for struggles for power between Denmark and Sweden. But today, the activities in this castle are less violent, because inside this castle, Lund University Internet Institute has its facilities. We are going to talk today to the famous professor of sociology of law, Håkan Hydén. We will talk to him about technology and social change. We will talk to him about how internet and digitalization are becoming relevant topics to sociology of law. So, come with me. Welcome.
Thank you.
We are going to talk today about sociology of law, and you have been traveling Europe for a couple of years now, doing interviews with scholars in sociology of law, discussing different topics regarding sociology of law. And today it's your turn.
Thank you.
To be interviewed, and we are in the Internet Institute, and we will discuss also some issues around technology and social change. But first I would like to start with asking you about your background. I know you started out in sociology of law as a PhD student, and then you turned to law and then back to sociology of law again. Would you like to tell us a little bit about your journey?
Yeah, I was lucky to come in contact with sociology of law when I actually did my studies in law as early as in the late 60s. Sociology of law was then introduced as a subject by Professor Per Stjernquist at the law faculty. So I could take or study sociology of law as optional courses within my law degree. But after that, I took my law degree, went to Gothenburg District Court to be a clerk for 2.5 years. To get some practice before going back to PhD studies, which I had decided at an early stage. So, and at that time, you were supposed to also have a bachelor in social science to become a doctorate in sociology of law. So that was what I did. I studied a bachelor's degree in social sciences in the early 70s, before then becoming a PhD student at the department. So I took a PhD 1978
in sociology of law.
Sociology of law. Yeah. It was me and Karin Widerberg. We were the first having a PhD in sociology of law.
Having Per Stjernquist as your supervisor.
Both of us had Per Stjernquist, who was the initiator of the subject. And it's a part of the story is that Per Stjernquist, he started sociology of law, and he did that in a kind of struggle with what he regarded as more conservative lawyers at that time at the law faculty. So he took the subject and brought it to the social science faculty, which is unique in an international perspective, because sociology of law belongs mostly to law faculties, while in Lund it became a subject of its own, and at the social science faculty. So you can study, to do some information here about the department, you can study sociology of law on undergraduate, graduate and postgraduate level, and also become PhD, as you can in political science or economy and whatsoever.
But after your PhD, you decided to go back to law.
Yeah, but that's both right and wrong, because at that time I didn't have any scholarship for being a PhD. So I actually taught in law, in business law, the whole time when I wrote my thesis. And that was, of course, something which forced me to keep the knowledge in law alive and alert. So I was at the Department for Commercial Law, and some subjects lawyers have problems to teach and research on. Labor law, my professor at that department was Axel Adlercreutz. He himself was an expert in labor law. So therefore it was accepted at that department. But environmental law, for instance, it's nothing which lawyers, especially at that time, would like to take on. So I was actually the first one who introduced the subject environmental law at Lund University in the early 70s, because no one else would like to take it on.
Mm. And this was within the law faculty?
That was also actually at the social science faculty, because business, the Department of Business Law, is related to the education of economists and therefore located at the social science faculty. But I become later on these merits, teaching in labor law and some other subjects. I wrote some articles and some books. And on these merits, I became later on docent in civil law at the law faculty. Mm. So I belong.
You have been traveling between law and sociology of law in the beginning of your career, but ended up staying within sociology of law quite early. Mm. Could you say something about why? Since you have seen both sides, you have been within the law faculty and you have started a career there, and you choose to spend your career within sociology of law.
And of course, as many times, I mean, it's practical reasons. When I was docent in private law, I used that in order to apply for positions as professors at the law faculties in Oslo and in Umeå and some other places. And the dilemma for a person like me is that being doubly educated, well, that's fine, but nobody accepts you. The lawyers don't regard you as an expert in law, and the social scientists, they look at you with some skepticism when it comes to social science knowledge. But so I was refused a couple of times when I applied for professorship in different legal subjects. But then already in 1986, I applied for the professorship in sociology of law, the chair after Per Stjernquist. Per Stjernquist retired 78 or 1st of January 79, when I just had defended my thesis. So I thought that I will never become a professor in sociology of law, because that will be a fresh person. But it was a kind of interregnum for between 79 and 86 when it was announced. And I applied for that position, and after 2.5 years and some fights, I got the chair in sociology of law. And I mean, that was my dream, of course, after PhD in sociology of law and so on. So therefore I was stuck, so to say, in Lund and in the subject. So I thought, to be honest, that might be regarded as a bit provincial to become professor and stay as professor at the same university you have been educated in. So I tried to become more internationalized via turning to the subject of human rights and traveling around a bit in the world, in Latin America, Africa, and parts of Asia at that time, for a couple of years before then trying to develop the subject sociology of law.
I think we'll get back to your engagement in international development of sociology of law, but first I would like to stay a little bit with the discussion around the subject of sociology of law, because I think it's interesting that in Sweden sociology of law has developed as a subject outside law faculty. And in many other universities in Europe, you will find it within the law faculties. And at the same time, sociology of law in Sweden is fairly strong. We have maybe you can tell a little bit about this.
No, I definitely start with bringing up some points which make sociology of law in Sweden and in Lund unique, because my colleagues and my friends at different universities around Scandinavia and around Europe, they have had problems many times to defend themselves as scientists within a law faculty, since they are interested in this odd, for a lawyer, odd subject, because there is a huge difference between legal science and social science. To just make a brief remark about that, legal science is a normative science, and social science is more empirically and theoretically oriented. So that's definitely a problem, and I think we could be grateful, and I'm grateful myself, because we have been able to develop the subject without any fights with lawyers and at the same time, of course, since we are outside the law faculty, we are not a part of the law curriculum. We educate, as you know as well, a lot of lawyers in our courses, because they come and take it as optional courses, as I did once upon a time. We face that today also. 30-35%, I guess, among our fresh students come from the law faculty.
So this background brings us over to the question of what you regard as sociology of law. Is it possible to define sociology of law?
Yeah, that's a good question. I mean, at an early stage, when I started to teach sociology of law, which was mostly after I had become professor, and I remember people turned to me in pauses and say and so on, that Professor, what do you become actually as a sociology when you have studied sociology of law? And that's a classical problem, because I mean, if you are a lawyer, you don't ask, the students don't ask, what do you become after studying law, and what do you become after studying medicine, etc. But sociology of law has not a kind of practice field in itself, so it's a kind of discipline which you can apply in different situations. And I think, I mean, you become a much better lawyer if you have knowledge about sociology of law. If you can put law in social and societal context, you understand the legal regulation in quite another way. And you can also use it in quite another way. So I think it's of importance, sociology of law is of importance for lawyers, but it's also of importance for social sciences, which I might want to come back to, because I would start to ask, give an answer to your question. Sociology of law, for me to start with when I became professor, was a question of putting another perspective on law, because law and legal science is about knowledge about the content of the legal system and how to apply it in certain situations. Case. while sociology of law, in the perspective of legal science, complement by putting other questions to the legal regulation, to the legal order, namely what factors are lying behind. Why do we have law as such, and why do we have certain regulations? And on the other side, perhaps still more important, a sociology of law is interested in the functions of law, the consequences. What are the consequences of law in different situations? And these questions are, I would say, as important for law as the understanding of how to apply law in certain situations. So that was the first, let's say, approach I had to argue for these different complementary...
The internal and the external.
Yeah, it is. I mean, I used to say that every science has an internal and external perspective on its study object. Political science study the political system from inside and outside, and I don't take the time now to go deeper into that, but it's the same with the legal system. You can have an internal perspective, learning how it operates and how it should be operating, since it's a normative subject. But you can also take a step back and look at the legal system from outside and ask yourself these questions. Why do we have law, and what are the consequences? But that was, in a sense, I was not satisfied with that. I mean, being a professor in a subject which has another perspective on some other discipline was not enough. So together with people brought up in the subject at that time, we developed, and I tried to apply something which I call the cake, or the tårtan in Swedish, where you had a kind of a center consisting of social science theories, which was applied in different legal areas like environment, human rights, welfare legislation, social legislation, and so on. And in that way, sociology of law became something which added to the knowledge for within environmental science, within science about social issues, family or social welfare legislation, human rights, or whatsoever. And that was also a bit, I mean, it was not the final solution for me, so to say, because it was also a bit blur. I mean, what is sociology of law? Okay, we add to the understanding of these different subjects. So that made me finally come to what is then the truth for me, namely that sociology of law let's say the common denominator, or the core of sociology of law, is about norms. And sociology of law, it gives a kind of association to legal norms and legal rules. But in order to understand, as I said earlier, that sociology of law help lawyers to be better lawyers and understand the legal system. And the point is that legal norms or legal rules, they compete with other norms in society, social norms, economic and bureaucratic and so on, professional norms of different kinds. And in order to understand law in practice, how it operates, I mean, a more general understanding of the concept of norms and the different types of norms in society is something which for me, when I start thinking these terms, become, this is what sociology of law really and actually is about.
Let us come back to that, but would you say that sociology of law differs from other siblings of the subject, like law and society or socio-legal studies? Is there anything that distinguishes sociology of law from neighboring fields of external views on the law?
I think sociology of law is the broadest approach to, I almost said socio-legal studies, I mean to the relation between law and society. Because if you have legal sociology, adds to giving some data about the application of law in certain respects, but it doesn't help understanding either from a legal point of view or a social science point of view. Socio-legal studies is more a question of understanding. It's a bit broader. It's a question of understanding legal regulation from a social and societal perspective. But sociology of law then is it has a broader scope. It gives you knowledge about it puts law in a much broader context, which is about society as such and
norms
and norms exactly, and therefore I mean not to forget that aspect among these interesting questions you raised to me. I would like to say that underline that sociology of law has one face at the towards the legal science and another towards the social science. And I mentioned about the understanding of norms in order to understand, in general, in order to understand legal regulation. But norms also, the knowledge about norms is also very important in the understanding and the development of social sciences. Because that has partly to do with the fact that we are not usually aware of norms because they are internalized, as the sociologists say, they are embedded in structures of different kinds. And therefore, I mean, when we act in different situations in life, we don't think, which norm do I apply here? Should I apply here? Sometimes perhaps. But it's when life change in a divorce, or when society change, then we start to, you get a kind of mismatch between the norms you are carrying and the development of the social life in a divorce case and the society in other cases. And therefore, I mean, the knowledge about norms and the reflection about norms come to the surface when you face changes.
Does this mean that, in your view, sociology of law must not necessarily deal with what you could call traditional national law, but also other structures in society that acts in a similar way as law?
It happens to have this let's say title, sociology of law, but actually it's and I can't find up a better kind of
but you approach
phrasing.
it almost as if it is sociology of norms.
Yes, I do, and in that perspective, I mean, it is more of a general social science with relevance for law and legal science.
I would like to bring up, I mean, the fact that we are sitting here in Lund University Internet Institute. It's not a coincidence. To you, technology and social change has been one of the most important aspects of your work within sociology of law. Would you care to describe how you see technology and social change as something very important to sociology of law and to law?
my main interest for this approach is that it has implications for the whole society and the societal development. Technology lay the foundation of changes in society, so actually that would be my starting point in a sense, but and when society changes, and if we talk more in concrete terms, we are talking about a shift from an industrial society to something else, which is a question of going from the analog to the digital, or from mechanics to electronic technology. That shift in itself change the conditions for norms, and especially legal norms, since legal norms compared to other norms, they are very stable, or since they are
resistant
formalized
to change.
Yeah, in a sense, and the raison d'être for legal regulation, or making some norms legal norms, is to make them stable and resistant to change, and that functions well in a society undergoing a linear development. But when you have reached a peak, which we did according to Manuel Castells and some others already at 1970, then things in society changes, and then you get a huger and huger misfit between regulation and society, what Carl Renner called substratum and regulation. And I think that is makes the focus on technology and social change important, because the technology totally change the substance of norms, the substratum of legal rules, legal norms, and that is typically nothing either lawyer or legal scientist or social scientist face, because they have in a way the structure of their sciences put some blindness on these questions.
Is there similarities in the changes that you are describing that we are going through now? Are there any similarities to what happened when we went from agricultural society to industrial society? Is history repeating itself in a sense from a sociology of law perspective?
It does, and the most striking factor is that you're not going from, let's say, one kind of society, agricultural society, to an industrial society just like that, because you don't have any, in the beginning when a new society is arising, you have no role models, you have no references for the legislator, or even not even for the scientist. So therefore, I mean, it tends to start with self-regulation. You go from one stage of heavily state, or let's say heavily stage of regulation, to self-regulation, because you have to start fresh by understanding the new kind of...
and this is in the phase where an old society is starting to wither and to die, and this is
Exactly.
where law is not relevant anymore. You see that self-regulation grows as a
Exactly.
compensator for traditional law.
Yeah.
Not being able to cope with the relevant issues that are turning up. Yeah?
And that is what we face to a large extent. But let me have, since you asked about the transition from the agricultural society to the industrial society, mention that I mean, this shift was during the 18th century, but it was not until the 19th century we got legislation legislation in relation to the industrial society or the market economy. This Code Napoleon, bürgerliches Gesetzbuch, and our own contract law and property law regulations, they came quite late in that development, and probably it will be the same now. I mean, the regulation of IT questions, it will take some time, and today it's the regulation is set up by law firms and actors on the market to a very large extent, and you might have small. It starts also. It's like a shift, paradigm shift, that it starts with trying to make the old paradigm fit into the new phenomena, and you can do that for some time, but at a certain stage, I mean, it's open for everybody that this is kind of fake. So you have to start with building a new paradigm, and that is also something which will come, I guess, in relation to IT.
In relation to online activities and internet, there are problems that are emerging now that law has big difficulties with handling, like copyright. You have file sharing. You have hate speech online, where law has very big problems with trying to figure out how to handle these issues. Do you see any signs of self-regulation that are starting to emerge, or is it too early?
No, I think it's the easiest way to give you an answer is that it's too early. But if you scrutinize what's happening, I mean, let's say behind the official surface, there are probably a lot of initiatives in order to deal with these things, which are important. Even if I, at this stage, wouldn't be able to point out that this is a typical such an initiative of self-regulation. But of course, I think it's a lot of interesting initiatives taking place here. And I mean, you and I, once upon the time, took the initiative to the research project about cyber norms, which is very important and have a lot of interesting followers among the young scholars and colleagues of us today, which will be able to give us answers about these questions. And one of the perhaps most severe aspects of let's say, how the new technology, let's say, produce problems which we don't have tools to handle like that, is about surveillance. Which is a great problem all over today, and not least for sociology of law and lawyers to cope with.
When you talk about self-regulation, how differs that from Ehrlich's concept of living law?
Yeah, I think that Ehrlich's concept of living law is about a misfit of traditional regulation coming from in this case for Ehrlich, living in Bukovina, in the outskirts of the Hungarian-Austrian Empire, Austrian-Hungarian Empire. Then the judge, Ehrlich, didn't recognize, he could see that regulation coming from Vienna at that time. It was sometimes of no relevance, and many times it was it treated the normative aspects of ordinary people's life, and so that was, I mean, there are clearly parallels, but I think today you have, via the norm concept, you have possibility to divide and dig deeper into the concept of living law and tell us why do we have a misfit between what people think and how they are treated from the formal society, because it was at earlish time it was in a sense easier to spot. I mean, you had the people in power in Vienna, and you had people in the outskirts, and this didn't, the normative views didn't fit.
But Ehrlich's idea was that as a judge you must take into consideration the customs and the traditions and the norms of the society in which you are placed to take legal decisions.
In that sense, I totally agree with the relevance of that approach, and especially even if I don't think that's not necessarily judges who should have the role of articulating the normative premises in a new society, because the normative aspects is so, let's say, intertwined with the let's say knowledge about the phenomena. So I mean, the problem with judges today would be that they wouldn't understand the problems which the IT brings to society. They have problems, as we could see in many legal cases also, the Pirate Bay case and so on and so forth.
How do you differ norms from rules and attitudes, and are there any way, or law for that matter, are there any ways to clearly tell the difference between the different kind of normative statements that guide us?
No, I think norms or the concept of norm is equivalent to customs and traditions and so on and so forth. There is a different towards attitude, in the sense that attitude is a more psychological concept. It's a question how I regard something, while norms are a question about expectations, other people's expectations on my behavior. And one of the reasons of my interest to develop that concept and use that concept is the necessity to try to understand the motives of actors and organizations in society on a collective level. Today, I mean, it's only, or let's say the psychologists have the monopoly to explain why people behave in certain manners. And that's not something you can use on a societal level, because you can't aggregate different people's attitudes, way of behavior and understanding to get an explanation on a societal level, because you have much more other structures also intervening there. So that's one very important aspect of for me to use norms, because if you can let's say understand the norms behind certain behaviors in society, then you can also explain the motives, and you can also have tools to change or to try to influence, etc., if you want to.
This strong emphasis on norms, that you are a very big part of having created at Lund University, the Sociology of Law department at Lund University. It differs from how other scholars view sociology of law, or is there an agreement internationally, or at least in Europe, that this is the path forward for sociology of law? Or are you on a sidetrack yourself?
No, I don't think so, actually, because it's nothing which is contrary to the understanding of let's say, common knowledge in sociology of law. As I regard it myself, it's more a question of trying to make it possible to accumulate knowledge, because that was something which also annoyed me for long as being a early professor in sociology of law, was this, that you have studied about that environment, about family issues, about social welfare issues, and many interesting studies. But I mean, they didn't add to each other. They didn't add to a larger understanding either of law or society, in my mind. So therefore I think that the concept of norms makes it possible to systematize knowledge in quite another way. And I usually I regard sociology of law as having the potential of being a strong interdisciplinary discipline, since what the norm concept in my mind does is to level the playing field. So you can study a phenomenon from a legal point, legal norms, social norms, economic norms, you name it, and put it on the same table, so to say. And in that way you get the kind of language in order to speak about these things in a more, let's say, coherent way, compared to having these different studies landing in different other disciplines.
Have you seen signs of that? I mean, you can see the potential, but have you seen it actually coming through? Do you see this accumulation of knowledge taking place already, or is that something that we have to look forward to?
To a large extent, hopefully, we have to. Well, we may look forward to it, but of course there is a lot of doctoral theses in sociology of law which add to a more systematic knowledge in the direction I'm arguing for, and. I mean, one day I might be able to go through these more systematically myself, and I mean, as you know, I'm trying to finalize for many years a book about norm, what I call norm science, or sociology of law as a norm science, and in that. Part, or in that perspective, in that book, I will certainly try to give an answer to your question. So that's I'm convinced that we already can see signs, even if it's perhaps not systematized enough.
How do you see the future for sociology of law, not only in Sweden but also in Europe and globally?
Yeah, of course, you are arguing out of your own interest to a certain extent, but I think the future of sociology of law is bright in the sense for different reasons. One, we have discussed before here, namely the changes in society. The changes in society makes a traditional legal science not enough in order to fulfill the needs for regulatory mechanisms in society. So I think And that's already taking place, as I said, by practitioners, by lawyers at big law firms and so on and so forth, that they come up with different solutions. And sometimes we have discussed at the department the goal of studying advanced practice. I think that is a question of mapping what is going on out there in terms of changes in practice. Because science, especially social science, have a dominance of empiricism or empirical load. And the problem with that is that first you have to have the changes before you can notice them, and therefore we today have to go out in society, look for these changes, and be a part of the communication, or let's say the communication with practitioners. We have the advantage as scientists to be able to. We have time to reflect about things which for the practitioners just happen like that before his or her eyes. So I mean, otherwise you could ask yourself, why should we have science if we don't have anything to contribute to as such? But I think we can contribute by systematizing what's going out in the field. And
to you, it's understanding change. That is in the core of why sociology of law is needed now.
Thank you.
Yeah?
Yes.
But how I mean, there are signs that sociology of law is weakened in Europe. So why is that? If there is a need in these times for sociology of law, why can we see signs that sociology of law in law faculties are living quite a hard life?
I think it goes back to what we talked about before, namely that sociology of law has been a part of, or is a part of, the law faculties. And the law faculties, they have no reason, so to say, to discuss in the same way as I argued for, namely go out there in society and look for what's going on and try to articulate that in scientific normative terms, because it's not a part of the traditional legal science paradigm, the legal dogmatic paradigm, so which dominates. So I think the bottom hasn't been reached yet, actually, in science. So at the same time, I mean, if you look worldwide, you can see a great interest for sociology of law in Latin America. And
in Asia.
And in Asia.
I know you are just back from China, where you have where you are having discussions with a university to include sociology of law in the legal teaching.
And the interesting thing with that was that I didn't have to, sell the subject. They got to know about the existence, and we had a visit from a university in Inner Mongolia at our university, and then we were invited. I was invited to talk about these things, and they said, and as late as today, I got confirmation that they will translate books from English to Chinese, and they will start a change of their law curriculum in relation to having sociology of law. And the point is that would be the first time where sociology of law could be brought into the traditional legal subjects. To study civil law, criminal law, or administrative law, it's very important to actually not have sociology of law as a separate subject, and then you have these other legal subjects. You must integrate them in order to get some benefits, and they are totally prepared to do that. which is a sign of also, I mean, that the China is a continent which will undergo rapid changes, and the leaders, as they say over there, they understand the need for modernization or of education in that perspective.
We mentioned it briefly earlier, your engagement in international sociology of law, and especially in human rights. You have for many years now been applying your sociology of law research to human rights issues. Could you tell us a little bit about that?
Yeah, I think human rights makes sociology of law very relevant for different reasons. Why? One reason is this international background human rights start with, so to say, and then they are implemented in domestic legislation. And that in itself makes it important to understand the processes. But perhaps still more important is that human rights works more as a mobilizing tool, in my mind, than a legal regulation as such. Because many times the legal regulation is a bit, I mean, if it's without sanctions directly, if they are not built into domestic legislation and so on. But it's this to understand how human rights could start processes of discussions and give rise to end use, fighting for a specific human rights, etc. It's these, let's say, processes which I find most important, and they tend to fall apart in the perspective of legal science, because legal science, for natural reasons, are more focused on the specific written legislation and on cases. But cases might be also a signal for discussion in society, but the most important aspects of human rights are what they initiate in terms of social movements and end use and social processes. And that is something which asks for a sociology of law approach.
And this is also an area where digitalization of society and internet has come to play a big role. Human rights is now something that is discussed online all over the world in a new way. Is that affecting also law's ability to resist or to embrace human rights?
No, I think it's. I mean, law changes after having faced and confronted with public pressure of different kinds, and you can see that if something happens in society in relation to a specific regulation, the law is sharpened in different ways. So it's a kind of staircase, the development of law follows. And that is something which I think will go still quicker in the future. The possibility to put pressure on those persons in power is much greater when you have these online missions or calls for opinions against people in power.
Finally, I would like you to, because you have been doing these interviews with prominent sociologists of law in Europe now for a couple of years, traveling with the film team and meeting interesting scholars. After this tour, Sociology of Law tour that you have done, has your view on sociology of law changed in any aspects, or is your view the same after having done this, talking to so many scholars?
Yeah, in a way, I mean, to be honest, my view is almost the same, but the mission was not primarily that I should learn as much as via these interviews try to teach people listening to these interviews. So I haven't gone through them, to be honest, now in a systematic way, but my impression is that these interviews, they reflect fairly well a kind of mainstream discourse within the subject. And that's good enough. And I couldn't resist to bring in a question about norms, for instance, and the colleagues or the interviewees, they were the professors. They were very, quick to adapt to that topic and made comments. So that it seems that they could relate to that approach, which I briefly then introduced quite well in relation to their own subject. I mean, and of course, there are subjects like living law and well known for scholars in the field that easily, I mean, could be referred to the concept to norms. So, but perhaps it was the easiness which they showed to adapt to that approach was a bit positively surprising for me, which encouraged me then to put that perspective forward still more in the future.
Okay, Håkan, it's been very interesting to have this talk with you, and so I thank you very much for participating in this interview, and thank you.
Thank you for taking the initiative to the whole series in a way, and to giving me this opportunity to make comments in the same way. Thank you.